Good evening, everyone. First of all, I want to begin by welcoming everyone. It's wonderful to have multiple shuls. It's our second week of coming together, shuls from Sydney, Australia, but also Western Australia, and to come together for some learning. We are in the lead up to Shavuot, the festival of the giving of the Torah. Torah and the learning of Torah is on our mind. And we are here for our second session with Professor Chaim Saiman and Rabbi Justice Marcus Solomon. The thing I enjoyed most about the first session, in addition to the information and the knowledge, was the camaraderie, the to and fro. I think there's something very interesting and dynamic about being a part of a conversation, watching the to and fro, which is different from perhaps the lecture style shiur that we may be used to. And I very much enjoyed watching the two minds, both with their differences and similarities in the way they bounced off each other. Tonight's topic specifically is a focus on contrasting Jewish law and secular law. One of the first shiurim I ever experienced giving was when as a teenager who'd done my fair bit of Gemara study, I was asked to give a shiur to a group of lawyers as a fill-in for a rabbi who was away. There was a group of lawyers, and interestingly, Rabbi Solomon, there was one judge, and he was an elder, retired judge, and he sat at the top of the table. This was in Morristown, New Jersey, and there I was giving the shiur, and the shiur was Bava Kama. And basically, it was all the laws of a cow that gored another cow and a fence. And we would learn 3 lines, and then they would break out into this discussion. Okay, what about the 21st century version? So cows got switched to dogs, fences got switched to gardens, and wheat fields got switched to apple trees and bushes. And they would all argue what the law in secular law would be. And then they would come to the head of the table and they would ask the judge to rule on it. And very much it was very little Gemara and much more an opportunity for these ex-law or current law professionals to compare and contrast how would Gemara work. And the truth is that there are a lot of similarities, a lot of yeshiva students who then went to ply their trade in law. But of course, there are many differences between the structure of Jewish law and secular law. Of course, both of you are experts in both of these areas. And to take us into the journey of contrasting these two bodies of law, I'm going to hand over to Professor Chaim Saiman and Rabbi Justice Marcus Solomon. Just before that, for anyone who has questions as we go through the evening, please feel free to type them into the chat box. Rav Shua will be curating those messages, and then towards the end, we'll be able to address them to our 2 hosts tonight. B'chavod.
Thanks, Rabbi David. Can I be heard? Can someone confirm that I can be heard?
Loud and clear.
Excellent. Thank you very much. Thank you. And hello again to everybody, and of course, especially to our special guest, Professor Saiman. So I'm going to, good morning, yes. I'm going to start with an overview, but in order to entice people to remain vigilant, I want to, and perhaps foreshadow that one of the things I'm going to talk about is in Australia, particularly. I'm going to invite Rabbi Saiman I'm going to tell him a little bit about this and then invite him to comment. And this will be towards the end of tonight, just to keep a sweetener for you. And that is that I do want to talk about probably the most well-known interface between Jewish law and civil law in Australia in the last couple of years. In fact, the last 10, 15 years, has been the Supreme Court, the various Supreme Court treatment of Beth Din decisions here in Australia, which have a rather unhappy history. So I know that there's a lot of interest in that. So I'm leaving out till further down the track in order to motivate people to stay. So that's just by way of foreshadowing what's coming for dessert. Let's begin with perhaps an overview. I think this is an enormous topic, the interface between Jewish law and civil law, and we could be here every night for many nights discussing it. But so I think we've got to narrow it down, but broaden it out to a few conceptual things, and then perhaps narrow into a few specific things. So let's begin. I think most people, or many people, will be familiar with the idea that there is a fundamental difference in approach between Jewish law and civil law, and that is that civil law is really, in many respects, a rights-based legal system, whereas Judaism is an obligation-based legal system. And by the way, that's not only a unique feature of Jewish law. When I was at uni, we had a very strong-minded, if I could put it that way, jurisprudence lecturer. Jurisprudence is the philosophy of law. And she was one of Australia's foremost feminist academics in the legal context. And we were required to do a whole lot of reading on feminist critical legal theory, which made the same point about rights versus duties. So that's a well-known distinction. And perhaps what we'll do is we'll kick it off by asking Professor Saiman to just give us a broad overview of that difference, and then we'll perhaps drill down to a couple of things. Professor Saiman, over to you.
Sure. Thank you. Thank you all. And good evening to you. Good morning to me. It's still waking up. Get the headphones on so that the rest of the house doesn't wake up. They look a little goofy, but my kids will appreciate it. So that, I think there's sort of two kind of big distinctions or that we'd like to talk about, one which you raised. So this is the rights and duties. I don't, so far as I know, the person who popularized this distinction, his name was Professor Robert Cover. He was a professor at Yale Law School. He unfortunately died quite young. He died in his early 40s. But he's really the first, he started in the 80s writing about Jewish law and secular law. And because he was a professor at Yale and very well known for things other than Jewish law, he was sort of the one who catapulted the discussion of Jewish law in sort of elite academic circles in America into, if not quite the mainstream, but into a polite company. And he wrote a very long and complicated article that people still read and don't understand, called Nomos and Narrative. But then he wrote, it was at a conference. It's a very simple 10-page article that's really just his speech, where he made the following point, which again, I don't think he originated, but he certainly crystallized, which is sort of concurrent with what you just said. And he says, look, the central concept in halacha is mitzvah, right? An obligation. And we talked about the mitzvot. And there's mitzvot ben adam lamakom, between man and God. And there's mitzvot ben adam lechavero, between people. And that is like the basic unit of analysis. What is my obligation? By contrast, in secular law, the basic unit of obligation is my right. And while, of course, there's no God in secular law, there's rights vis-a-vis the state, and there's rights vis-a-vis other. So it has a similar structure. But what Cover did, he made two other moves that I think are interesting. One, he said, each of these connects to what he called the foundational narrative or the foundational myth of each system. So, and we're counting towards Shavuot. And he says, where does Jewish law begin? What is its foundation story? Its foundation story is Ma'amad Har Sinai, the revelation at Sinai. And he says that narrative tells us of entering into the covenant with God and then with each other. And therefore the obligations that flow from that covenant. By contrast, he says the narrative of the birth of civil law is the state of nature, and right, that we're sort of born conceptually. Humans are born free with no ties and no obligations. And then to create society, they come together and they bargain some of their freedom for the security that a civilization and then a state provides. And therefore, he says, right, that's the foundation narrative. We're born with all our rights and we trade them away for the protections of society. as opposed to Sinai is that we're born into obligation. So I think that's one core point that he made, which is very interesting, especially as we start thinking about Shavuot. So it's not just that there are rights and duties, but there's a reason for that. And that tells you something about the deep structure of the system. The other point that he made is that while on the one hand, you can think of a right and duty as being correlative of each other, right? So if I have a duty to pay Justice Solomon $100, we can turn that around and says he has a right to demand the $100 from me. Cover thought that the way you talk about it matters, right? Because certain things are easier to do or harder to do if we start thinking of them as rights versus as duties. And maybe we'll give some examples down the road.
Okay, thank you. So that's an excellent overview. I mean, broadly speaking, just to bring people into the picture, perhaps the most well-known and easiest, clearest example to relate to is the pasuk we had a few weeks ago in Parashat Kedoshim, Lo ta'amod al dam re'echa, do not stand by the blood of your neighbor. And Rashi brings the classic Talmudic formulation of that obligation, and that is that if you see someone who is in danger, drowning in the ocean, being brutalized by wild animals, you have an obligation to save them. In Judaism, there is an obligation to reach out, to use a contemporary expression, and lend assistance or save another. Whereas in our civil legal system, there is, broadly speaking, no such obligation. So we don't have a system whereby obligations are imposed simply because we have another responsibility for another human being by virtue of the fact that we're both human. So in our civil society, obligations can be imposed if you have assumed what the law calls a duty of care. You're a teacher, you have a duty of care to a child. You're a doctor, you have a duty of care to a patient. So in particular relationships and contexts, the law will impose a duty of care. But beyond that, which the law construes by reason of the relationship, you have no duty to do anything to anybody else. So that's the explanation of it in the broadest sense. Let me just ask you, because I actually gave a shiur on this recently, and a number of chachamim in my shul pointed out that, in fact, I don't know what it's like in your shul, but in my shul,
I'm one of the chachamim in our shul. I sit in the back and give the rabbi a hard time.
So, we say in the Haggadah, Kulanu chachamim, Kulanu novonim, right? Kulanu, all Jews are chachamim, especially when the rabbi's talking. So there's people pointed out to me that apparently in one of the Northern Territory here in Australia, they've enacted legislation which requires a person in certain limited circumstances to lend assistance to another. And the Israelis were telling me that in Israel, there has been enacted certain legislation which requires people to lend assistance to another. So that's interesting, but what it does illustrate that you need special legislation to impose such an obligation, because the core common law doesn't include such an obligation. If you want to bring such an obligation into the law, you have to legislate it specifically. And there have been instances, for example, I think it was in Sydney years ago, maybe 2 decades ago, where someone was lying on the footpath, had been knocked over by a car, and thousands of cars just drove by, and nobody stopped because nobody felt an obligation. So that's a very crass example of that issue. But the truth of the matter is, part of my shiur was also the idea that it's really not possible to impose those obligations in a general civil legal system. It becomes impossible to measure the extent to which a person should be obliged to help one another unless you enact that legislation in a very specific example. The difference in Judaism is that not only is our fundamental cornerstone the concept of obligation, mitzvah, but the other idea that is embraced by Judaism is that we're not talking about a legal system for the whole of humanity. We're talking about B'nai Brit. We're talking about a covenantal community. The idea of a covenantal community in Judaism is that we do assume obligations towards each other, and we are a model society. And one of the things I was trying to address in that is because sometimes we feel a little cringy about saying this, but these obligations, love your fellow as yourself, do not stand idly by the blood of your neighbor, the simple mitzvah of returning lost property. Halachically, according to the Talmud, they only apply within the Jewish community. They don't apply, you don't have that obligation towards a Gentile. And people are a little shocked about that and understandably quite discomforted by that. But the key is to understand that no legal system imposes that obligation on people. What's unique about the Jewish legal system is that it's a manifestation of a covenantal community where people assume obligations of care towards each other. So I wondered, Professor Saiman, with that long and rambling introduction, whether you are aware of whether in America or elsewhere there have been inroads into this concept that might blur the distinction between rights and duties in the American legal culture.
Sure.
Or has it gone away?
Well, so let me actually step back and reflect on a few things that you talked about, and I'll end with the last question. Another important distinction, which is implicated by what you just talked about between Jewish and secular law, is what I call who's the law talking to. So, we'll read again on Shavuot in just over a week. Lo tirtzach, thou shalt not kill, or you shall not kill. Lo tinaf, do not commit adultery. It's talking to you, to the person. I don't know how the law in Western Australia is written, but it probably says something like, a person found guilty of Class A murder shall be sentenced to ... A person found to have committed larceny for, X amount of dollars shall be subject to the following punishments. In other words, the modern law, and you'll tell me in a minute if this is true, but the modern law generally speaks to the system, to the bureaucrat, to the judge, about what to do when X, Y, or Z happens. It doesn't say, hey, you citizen, don't steal. Jewish law sort of works the opposite, right? Jewish law, and by the way, not just Jewish law, I think older legal systems generally, say, hey, don't steal. And then on the back end, there's some discussion to the legal machinery about what to do if that happens. So I want to come to your other questions, but just let you sort of jump in on that as one of the people who is the machine. How does that hit you?
That's a very interesting observation now that I think of it. I mean, generally speaking, legislation dealing, for example, with offences, which you've just mentioned, is that the legislation will say, so if a person who does X, Y, Z commits an offence and is liable to whatever, however many years of imprisonment or a fine, so that it is written in that, you're correct, I think, broadly speaking, that it's not addressed to the person, it's addressed to the person indirectly. That is, if a person who does this commits an offence, and this is the consequence of the offence. But what do you think is the significance of that? What's the significance of the fact that Judaism, in the way it frames the law, talks to the individual citizen, whereas in our civil system, the way it's framed talks to the system or the machinery, as you say, and refers to the citizen as a third party or a third in the third person. What do you think is the significance of that?
Sure. So I think it's actually, I didn't bring it up randomly. I think it's a little bit related to some of the things we talked about. So first of all, and again, it stresses this idea of, the duty is on you. But beyond that, it gets a little bit to your question of lo tamod adam re'echa. In other words, in the civil law, unless there's enforcement, it's hard to see what the law is doing, right? In other words, and I think that's why certainly crimes and fines and things like that are always are because it's not speaking to like the sort of moral or religious or even cultural, social sense of the person. It's speaking to the state and its machine and what's going to happen. And I think Jewish law does not do that, right? In fact, both historically and even conceptually, the machinery of Jewish law is pretty weak and maybe not even there half the time. To take your example, lo tamod adam re'echa, and maybe even a broader idea because it applies more situations, but is analytically similar. Hashavat aveda, returning lost object, are not mitzvot that their violation can be enforced in a Jewish law court, even if we were living in a idealized halachic state, because these are lav hanitak laseh and lav hanitak leshavon and various technical reasons why would not be any actual enforcement. In other words, there would be no machine or state. If I fail to return a lost object to you, I cannot be sued for that in a Beit Din, in a halachic court. Nevertheless, we don't think that it's any less of a mitzvah or any less of an obligation to do. In other words, it's very easy in Jewish law to split the question of the duty and the obligation from the question of enforcement. In large part because we think that human enforcement is only one part of the system. We believe that God keeps score. How? I don't know, but I believe that God keeps score. I don't go much beyond that because I think that gets dangerous. However,
I guess in the civil system, there's no point in a law that doesn't have its accompanying attendant means of enforcement.
Exactly, and I think that's why they're written that way. They're written that way from their birth, because that is the only way that makes sense. Whereas in halakha, they're written as don't do this, and then there's like a second order and third order discussion about what happens if you don't, who does, the punishments, etc. But that's secondary to because it's like who it's speaking to, who is the addressee of the law. So I think that gets a little bit into, I think, why civil systems have a harder time with something like lo tamod adam re'echa or hashavat aveda, because as you said, imposing those duties categorically, I want to get to the achicha point in a minute. Imposing those duties categorically is hard, right? There's going to be all sorts of situations, right? I'm on my way to work, I don't have time, where it's going to be hard to impose it in a way that we're going to enforce it. But to set out a moral marker that this is how you should be thinking, that's, so to speak, easier to do. And that's something that halakha, as a duty-based system that is not immediately concerned with how we can enforce this duty, has an easier time doing. To your point about the Jew and the Gentile, I think your description of halakha is correct. I think your description of the discomfort is correct. And I think your analysis is somewhat correct. In other words, I think what the Torah is trying to do with the word achicha is basically expand the definition of family. So if you go and you see your literal brother on the side of the road, right, you're not going to say, well, the law doesn't require me to aid my brother. You're like, he's my brother, I'm helping him out, right? We treat, we'll call them obligations within the family in a very different way than we treat to society generally. And I think part of what's happening here, and I think you can see this somewhat consistently in the Torah, that the word achva or achicha, brother, is meant, or
often
right, is meant to say, look, there are certain things that you do for family that you don't do for everyone else. Let's expand the definition of family. I think if you think about it that way, it puts it in a little different character. Now, in my view, if the state comes and wants to say, listen, everyone's got to aid everyone else, or everyone's got to return everyone else's aveda, then of course, as a matter of Jewish law, you have to do that to everybody. because it's the state law.
Yeah, but it's more than elevating a familial relationship, isn't it? I mean, it's
I think that's the model. In other words,
yes,
I think
but
the
it's
model
taking
is,
the model of family and imposing it on a covenantal community,
yes, I think
a
that's
community bound not just by familial relationship, but by mutual covenant.
I think that's right. But I think the model is that some of these things, some of these halachot that you're talking about, don't even need to be stated vis-a-vis family and are expanded outwards under Jewish law. Just to your last point, now finally. So America, so one thing that is European-based systems, and those coming from the Roman law, have a somewhat easier time than those from the English common law, which Australia and America are sub-branches of, imposing such duties. So far as I know, the French code, the German code, these do have some version of a lo tamod al dam re'echa law. As you noted, the Israeli law is actually called lo tamod al dam re'echa.
Yes, someone told me that.
It's the name of the law, clearly influenced by the Torah. In America, this is probably most famous, at least to people roughly my age, as the Seinfeld law. So, so I don't know how much Seinfeld penetrated in Australia. My guess is amongst
big time. Where Australia's very Seinfeld.
Yeah, my guess is that a bunch of Jews know Seinfeld. It's one of the classic Jewish shows. So anyway, it's
still running here every night.
Okay, so the final episode of the whole series is, so one state in America passed such a law, Vermont, and it's very interesting. The Vermont law, the maximum penalty is $100. Okay, the maximum penalty under French law is 75,000 euro, just to get you a sense of where it is. So the most that could happen in America is Vermont, which is, people call it the People's Republic of Vermont. It's a teeny little state that's very, very, very liberal relative to the rest of the country. And they passed a law, and the sort of premise of the Seinfeld episode is that everybody from the whole series kind of comes in and indicts them as being a bunch of people who watch suffering and just move on. But what is interesting is that when you look at that law and the cases discussing things like that, they mainly talk about liability if you try to save someone and it goes wrong. This I find fascinating, is that if you look even at this Vermont statute, right, which is the most in the direction of what we would think of the halachic duty, 3/4 of it says that if you're trying to save someone and it goes wrong, you are released from tort liability. So to me, this was fascinating, because even the place where it looks, it's still thinking about this of the rights of the affirmative defenses, so to speak, that the actor would have if sued for a botched failure. Where, of course, you have to go very deep in the Jewish law sources, and so deep that it might not even be expressly stated anywhere, where it starts talking about, if I'm in the process of saving someone and I injure them or I make the matter worse, what happens?
Yeah, I mean, the American, if we could just digress for a second, the American legal culture, I mean, to many people, is quite extreme in terms of its rights-based and its obsession with freedom. And just to contrast that with Jewish law, for example, can I make the observation, which is rather tragically timely, that Chazal, for example, would have, in my view, no difficulty with enacting legislation about gun control to address evil, to address indiscriminate massacres in a society. Whereas this seems to be some part of the American psyche that infects their legal culture in a way that is utterly, it's not only utterly foreign to Jewish law, it's pretty foreign to Australians and in my respectful view, most normal people around the world.
Yeah, so that's, I would say we don't even have to speculate. There are express halachot about who one can sell a sword to.
Yeah. Yeah, I was going to. Yeah.
So
in
other words, one need not even say what Chazal would have done, as you know. What we can say what Chazal did, and they said you're not allowed to sell a sword to this person and that person because it's dangerous. So I think that's right. And as you're referencing, just yesterday there was, I hate to say it this way, another tragic school shooting where I think now 18 or 19 or 20 people have died, in another person who enters into a school and starts shooting. Right. So there's, I think, two questions here, one cultural and one legal. A, why does this happen in America? And B, why is America so resistant to gun control? I don't think they're actually the same question. There are other societies where guns are very prevalent, right? So
Israel, for example.
Right, let's take in Israel, right? So in Israel, you see something that you don't see in America. You'll be on a bus and there'll be an 18 or 19-year-old kid with an M16, right? That's a very normal sight. Now, yes, that person is wearing a green uniform, but still, young people walking around with automatic weapons in Israel is an extremely common sight. In fact, even as an American, very, very jarring. On the other hand, of course, Israel's a smaller country, but nevertheless, for all of its issues and all of its problems and all the security questions in Israel, you do not hear of something like this happening. So, as you noted, this has become a very political issue, almost a totemic issue of totemic significance. I'll send around. I wrote a little article. It then worked its way into my book on a sort of Jewish view, not so much of gun control, but about the totemic significance of really a sword. Chazal talked about it, but I think it's very connected to American ideas of, or certainly, I would say, first of all, when we say American, now we'll talk about half of America, right? America is a very divided country. Much more so, I think, much more polarized than I think Australia, which is why its political culture looks that way. And once something becomes a sort of symbol in this debate, reason goes out the window. So up until relatively recently, the American Constitution was not understood to protect an individual right to gun ownership. That is in the last 15 years or so, the Supreme Court decision on a 5-4 decision, I believe in the late 20-aughts or early 20-teens. Justice Scalia, writing for the court, basically took the Second Amendment, which we could Talmudically analyze and debate for weeks, and basically said this provides an individual right for gun ownership. There's probably going to be another case coming down the summer, even expanding that. So I would say what is going on in America, not only is guns not regulated, but they probably can't be. In other words, it's become not just this is a choice a legislator can make. And you'll just I'll say, right, just to kind of concretize this, so we're now in sort of primary season for elections. So I believe one of the candidates, Republican candidates for Georgia governor, not the one who won, but again, just to give an example, they had the name and the bumper stickers on the bottom said, Jesus, guns, babies. Those are the three central platforms of the plank. So that just gives you a little bit of a sense. If one wanted to think about what a molech is, this might be a way to go.
Yeah. So the legal culture in America then is perhaps the extreme version of the antithesis of those aspects of Jewish culture. And we could get on and discuss how that manifests in the renewed or resurrected debate about abortion. But I think that'll take us down another rabbit hole. What I wanted to come back to now is to talk about a controversial interface in Australia and between Jewish law and civil law. So just to fill you in, and that is that we've had, over the last 20 years, we've had a number of challenges to Beth Din arbitrations here in Australia, both in the Supreme Court in Victoria and the Supreme Court in New South Wales. I think it's correct to say that every single challenge has succeeded and that the Beth Din ruling was overturned. But there was a particular, that for various reasons that would present, you know, a 3-hour lecture in itself. Fascinating, but we don't have time. But the most interesting one I wanted to ask you about was was one where the Beth Din, there was an arbitration agreement that was itself the subject of considerable dispute what its terms were on its proper construction. But the Beth Din required both parties to appear before the Beth Din. One party refused to, well, it's a question of whether they were a party, but just put that aside. Let's say one party refused to appear before the Beth Din, and the Beth Din imposed sanctions on them in the nature of a siruv, a type of a mild chayrim, banned them from being, I don't recall exactly what the sanctions were, but they related presumably to things like getting an aliyah in shuls, and it was a religious social sanction. So what happened was that was the case in the New South Wales Supreme Court didn't start on that basis, but it evolved into a question of whether forcing someone, so to speak, to go to a Beth Din arbitration and therefore not pursue their rights in a civil court amounted to a contempt of court because it undermined the administration of justice by preventing someone to have unfettered access to the civil courts. So the judge held that it was a contempt on the part of the Beth Din to impose such sanctions. It went on appeal, and on appeal, 2 judges upheld the contempt, and one judge said, well, these are all members of a religious community. They can leave the religious community if they want. This is a matter of, in a sense, a form of freedom of religion. And she upheld the appeal, but she was in the minority. The matter then went, there was an appeal to an attempt to appeal to the High Court in Canberra, and that failed. So the end result was that we have the New South Wales Supreme Court in what is really a binding decision, saying that if a Beth Din imposes sanctions in order to encourage or force or require, put a social sanction on someone to come to a Beth Din rather than pursue their rights in civil court, that amounts to a contempt because it undermines the administration of justice by fettering a person's ability to go to pursue their rights in civil court. Now, it's been suggested to me, and I had a look at a number of American cases, there wasn't an American case precisely on point, but there are a number of American cases that sort of dance around the issue with a civil for refusal to give a get. It seems to me that the American jurisprudence, with its emphasis on rights and the ability, the freedom of religion and the freedom to do what you want, might have come to a different result. Do you have a view on that?
Yeah, no, I think that's right. So American law here is quite different. As we've talked before, I think American and Australian law both, flow from the English system and are largely, I would say in many places in sync in the principles, if not in the details. But here, I think there's a place where there's a difference on the basis of principle. Like you said, the idea of freedom of religion is very, very strong, and in fact, getting stronger with this very conservative Supreme Court. There's decisions the last several years that have expanded freedom of religion. But as I think the whole structure of the way it views both arbitration law and religion is quite different. So I would say, as first, in American law, just arbitration is very permissive. I think more permissive than in England, I know for sure, and probably in arbitration. I think the American courts would certainly side with the dissent in that judge. And there are cases where they say sort of what that judge says, where they say, listen, there's you don't have to belong to a shul. You have no right, let's put it in terms of rights. You have no rights to go to a certain shul. You have no rights to send your kids to a certain school. You have no rights to enter a mikveh or whatever. These are all private and religious institutions. that are allowed to structure their own membership per their criteria. And therefore, if a community, now legally, there's no such thing as a community in America. There are, there's the shul, there's the school, there's the mikveh, there's whatever. If all of these collectively decide that we're not going to allow, Mr. Schwartz to enter the building because of whatever, there is nothing that the state can do about it. And therefore, a seruv in which a Beth Din basically signals, right? At least in America, the Beth Din doesn't directly control any of these things, but it signals, it uses its communal authority to say, hey, don't let this person in. There's nothing that courts can do about it. More than that, the courts have held that if a person submits to binding Beth Din arbitration because they're afraid that their kids will be kicked out of school, shul, etc., that is going to be very difficult to challenge. In other words, it's going to be hard, I don't want to say impossible, but hard to raise some sort of duress or unconscionability claim, because again, there's no obligation to go to this place. I suspect that at the extreme case, a court would hear such a thing, but it's going to be pretty hard to do. So what we have here is this, like, I would say you have to look at this from like two sides of the eye. From the perspective of Jewish law, we would say there's a halachic obligation to go to a Beth Din. Yet from the perspective of civil law, we would say this is a voluntary assumption to submit to the Beth Din's authority. And there's a little dancing on the head there.
If the person refuses to submit, and the effect of the Beth Din's conduct is to fetter their ability to pursue their rights in civil court, that would not trouble an American court, you don't?
Not at all. Not at all. It would say, first of all, it would never, what I understand the Australian case, that they went after the Beth Din themselves, right? I cannot imagine that happening. I cannot imagine that happening. I think what they would say is, you can go and you may suffer the communal consequences, but it's your choice to be Jewish or to not be Jewish. In other words, it would. There's a case, Greenberg versus Greenberg, I can send you, that basically says this directly. In other words, being part of a religious community is a voluntary association, and therefore the community can structure that any way it wants, and it's not telling you not to go to court. It's telling you if you go to court, your friends won't talk to you. But the Constitution and the law doesn't protect your friends not talking to you.
I want to change gear to a different thing, which an entirely different distinction, which I find very interesting between Jewish law and civil law, particularly as a judge, because one of the things that I think is a fascinating aspect of Jewish law, which really has no parallel in civil law, is the approach to compromise, or what the Talmud calls bitzua or peshara. So in civil law, and I know there's a chapter in your book about this, so I'm keen to get your comment, but in civil law, there's an expression we often use, and that's called, we settle out of court, an out of court settlement. Because in civil law, in Australian law, American English law, I should imagine as well, there is a very bright line between compromise and the application of law. So once you're in the courtroom, the only business of the court is to apply the law. The court doesn't engineer compromises, and the court cannot hear discussion about compromise. And that's manifest in the expression out of court settlement. In other words, a compromised settlement bears no relationship to what happens in court. The two are very distinct. And indeed, there's a rule of evidence that you can't give evidence about what is said in the pursuit of a compromise in a courtroom. But we know in Jewish law, in the discussion in Sanhedrin, that the court, there's this concept of a judicial compromise. And so that the parties are invited at the beginning of every case, and indeed the Beth Din is mandated to urge the parties to empower the court to come up with what the court considers not the application of law, but the application of what it considers to be a fair compromise. And that strikes me as a very interesting and quite a stark contrast between Jewish law and civil law, and Jewish law's emphasis ultimately on the objective of harmony, as distinct from the application of God's law, which itself is ironic, whereas the civil law, the object of the civil law is only law. It's not about human harmony, or shalom, as the Talmud characterizes it. You've got a bit about that in your book, Professor Saiman, so I was keen for you to make some observations about that.
Yeah, let me start by connecting it to our last discussion. I think this is one place where American Beth Dins can get in trouble. And if I recall, there's a case where one did get in trouble.
Here as well, they got into trouble with this as well.
On this, which is to say that if I recall the facts of the case, precisely because in halacha, when you're at a Beit Din, the difference between what the Gemara calls din and pshara, right? So law and compromise can be fuzzy, and we'll talk about that in a minute. A Beit Din can often switch and say, okay, so here's what could happen. And I've been in a case, like this, and we worked around it. So we're talking to the parties, and I said, okay, guys, you know what? Let's try to get a compromise here. So party A, please leave the room. Let's talk to party B for a second. And we say, okay, guys, listen, here's where this is going. Like, what do you think about this number? And then say, okay, switch. Party A, come back in. Party B, leave. Guys, look, they really want to hear it. Now, that's a totally valid thing for a Beit Din to do to kind of structure compromise. What we've just done now in civil law terms is that we had ex-party communications. And therefore, this could be challenged in civil court because we violated a kind of judicial.
But even in Jewish law, having had that discussion, you can't then, the negotiation fails. In Jewish law, you can then switch back to being the Beit Din. I would have thought that's a problem even.
Yeah, no, I think you could say that, listen, okay, we tried, this didn't work. We're going to revert now to din.
Oh, really?
I don't think that's necessarily a problem.
That's offline. I'm not sure about that. I got some difficulty with that, but we'll discuss.
Okay, but anyway, I think there was a case of a Beit Din doing this, and then the compromise failed, and they rendered their decision, and this got sticky. So we'll put a pin in that. But more generally, to your point, as you noted, even though, and I think this is a fascinating point, even though we say that the civil laws are God's law in Judaism, when it comes to actual application of them, there's a preference for pshara, right? And the Gemara says, and it's recorded in Shulchan Aruch, that you have to start the case by saying, like, do you want to do pshara? And clearly the thrust is to push them there. In fact, in contemporary, and by contemporary I mean since the 13th century, the Rush already talks about this, but this is true today. The document, the arbitration agreement in English, or the Shtar Berurin in Hebrew, that one signs when one goes into Beit Din, almost always says we're going to do either pshara or a kind of mixed concept of pshara krova l'din, pshara influenced or close to the din. In other words, that the whole mechanism through which contemporary Beit Din sit, for the most part, sure there are exceptions, is in the pshara framework, which I think also a little bit might answer the question that you raised before. This is quite different than in court. Now, just to push the other way, there was recently, I heard a shiur by Rav Asher Weiss, one of the great contemporary poskim in Israel, particularly on matters of civil law and Beit Din and things like that. And he said that he felt that sometimes the pshara instinct goes too far, and that in the community, and he's talking about a more Haredi community in Israel, there's a sense that, oh, anytime you go to Beit Din, they're just going to split the difference between them, And he said, no, we shouldn't do that. But so it comes on both sides. But there's definitely a sense of pshara, and as you said, the Gemara talks about what Rabbi Soloveitchik called a therapeutic jurisprudence. In other words, the goal is not just to make the fight go away, right? And as a judge, I'm sure you know, clearly what you need to do is to clear the docket, but the judge is to bring the parties Shinesu Ohavim Zeh, right? That they, and this comes from the Gemara in Sanhedrin, Aaron HaKohen being the model, that the result should not just be the dispute is over, but that there's been a reparative process.
Human harmony. I
human
like
harmony.
that expression, therapeutic jurisprudence. I'm going to stick that in one of my judgments. I like that one. But we're just running out of time. I wanted you to just raise briefly quite a big issue that we've only got a couple of minutes to talk about, and that is, how does halakha confront or accommodate entirely new, I'm not just talking about new inventions and electricity on Shabbat. I mean, many people have heard about that. I'm talking about perhaps more in a legal or commercial context. So we know that, for example, companies, a corporate entity, that was a fiction invented by the English in the 18th century or whenever it was. And all these different types of trusts and commercial entities and vehicles and instruments that have developed in commerce and reflect the way that people do business and govern their rights, which don't appear in halachic discourse in the Talmud. So everyone hears about how halakha approaches technological change in terms of Shabbat or genetics. But what about how halakha confronts these developments in, for example, commercial law?
Sure. So this is a fascinating story because it largely does, and I've been interested in this because it does with relative, and I'll underscore that, relative ease, certainly as compared to the way it confronts social changes. So in the Talmud, there's it's basically two lines, which become the beachhead for a tremendous growth of jurisprudence. There's the idea of minhag socharim, or it's called situnta. So here's the basic story. Under formal Talmudic law, if I'm going to take possession of a movable object, let's say a barrel of wine, I got to pick it up or maybe drag it, and then it becomes mine. Then I've taken ownership. So there's a story in the Talmud that some guy goes and he buys a warehouse full of wine caskets. And, that's probably annoying to pick up each one of them. So he goes and he puts his mark on them, maybe like a signature and initials. He says, this one's mine, this one's mine, this one's mine, this one's. And then there's a problem, but then the Gemara says that he has acquired them because that is the minhag socharim, that is the custom of the merchants. In other words, in that time, in that place, the market worked that you didn't have to pick up the barrel of wine, you could put your signature on it or whatnot. This then grows to encompass a very, very wide range of devices. And up to and including, I think the contemporary consensus would be, certainly the aforementioned Rav Asher Weiss is of the view that some combination of minhag socharim, the customs of the market, some combination of t'nai, the condition of the parties, the assumptions and the undina and the stipulation of the parties, and maybe some combination of dina de malchuta, of civil law, formal civil law, right? And we could argue, but some mix of all these things produces the ability that these devices will be recognized by Jewish law. Now, I'll just say, right, this wasn't always the case. If you go back 50, 60 years, Halachis or Moshe Sternbach or Menashe Klein were quite skeptical of the corporations in the corporate form. It says no such thing in halacha. But I think that as these things have just become embedded both in society at large and in our community, the idea that they're here and we got to figure out what to do with them has taken hold. And these are the various technologies. And I would say, right, if just one looks in the marketplace, it's very rare if we're in the market, right, leave out the religion side, that there are transactions that Jews don't engage in and that isn't ultimately recognized, right, by halacha. So if you make money through your corporate form and then use it to, right, the classic example in the Talmud is use it to be mekadesh and isha, to betroth a woman, nobody's going to say that money's not yours. If you buy your lulav with it, no one's going to say that lulav is not yours.
So that illustrates, I think, importantly, the flexibility of Jewish law to accommodate these developments that have no reference point in Jewish law traditionally. But
I'll just be fair. People make arguments, right, that there are sort of proto-corporate ideas in the Talmud, and I think that there certainly are proto-corporate ideas, but they don't become concentrated until very late.
I'm a little scared. That's like defying the Big Bang in the Psukim in Bereshit.
All right, we'll argue about that.
All right, listen, we're going to have to wrap up. There is a question, I'm told. Is the American Constitution based on religious values because the founders were Puritans, and the European law is predominantly based on the Napoleonic Code, which is not rooted in religion? I've got no idea of the. I'm assuming that question's addressed to you, Chaim.
Yeah. So I'm not the expert here. So I think, but remember, the Puritans are before the founding, right? The Puritans are coming in the 1600s, and the founding is not until the late the Puritans are in the early 1600s, early mid, and so we've got a time lag. So I mean, people argue about this, so let's just put it there. But the American Constitution doesn't overtly is not overtly religious. It says
one nation under God.
That's the Pledge of Allegiance, and that phrase was added in the 50s as an anti-communist thing, right? It does say endowed by their creator. That's in the Declaration of Independence. So there's religious talk around it. There are certainly a school of thought that finds it sort of very religious. There's certainly a school of thought that finds it more secular, that many of them were deists. I think the founders were, like any good society, all over the map on this. But I think it's a little bit too strong to say it's firmly rooted in religion. I think it's fair to say that, certain assumptions about religion were much more common and prevalent in the founding era than they are today, where they're more contested.
Yeah. The Lubavitcher Rebbe had a few observations about that. He placed much more significance on that, I think, theologically. But we've run out of time, so handing back to Rav Shua to wrap up. I think. Have I got that right, Shua?
Yeah. That's correct. I don't have that much more to add, except to thank both of you once again for such an informative and fantastic evening. This is a reminder to people, the second of a 3-part series. We've had the first 2. Again, for those who couldn't make it tonight, or you're on but you missed the first part, or you weren't able to be here for all of it, and for people who signed up but we're not here tonight, everyone will receive a recording tomorrow. A reminder that our 3rd and final part of the series is next Wednesday at 8 p.m. So please tune in for that. And if you can't, you'll receive a recording as well. But I just want to thank both our speakers tonight so very much for their time tonight, last week, and the time that goes into preparing this, and really being able to give us so much information in such a on such important subjects as well. So thank you very much, and a good evening to everybody, or good morning to the professor, but other than that, good evening and good night to everybody else.
Thanks, everyone. Good night.